All right, if you're gearing up for the bar exam or you're a junior barrister finding your feet, you know the affidavit can feel like a total minefield. But here's the thing, it's also one of your most powerful tools of persuasion. Today, we're diving into a playbook for drafting affidavits that don't just follow the rules, but actually help you win your case. Let's get into it.
So here's the game plan. We're going to start with why getting this right is so incredibly important. Then we'll cover the 2 foundational rules you absolutely cannot break. After that, we'll tackle the biggest hurdle for most people, the hearsay rule and its exceptions. And we'll wrap up with some practical, hands-on commandments to really make your drafting shine.
Okay, first things first, let's talk about the stakes. Before you even type a single word, you have to appreciate what happens when an affidavit goes wrong. This isn't just some academic exercise. This is about your client's case and your own credibility.
I want you to seriously think about this. You've spent hours, maybe days, with a witness. You've written what you believe is a killer story, but you missed one of the basic rules. So, what's the worst that can happen?
Well, the fallout can be pretty brutal. A judge can just strike out entire sections of your affidavit, or worse, the whole thing. Crucial evidence? Gone. You could also be hit with some serious cost penalties. But you know, what might be the most damaging thing is that the credibility of your evidence just tanks, and frankly, so does yours. The takeaway here is simple. You have to get this right from the jump. It's absolutely non-negotiable.
So how do we avoid that kind of disaster? It's actually pretty straightforward. You build your affidavit on 2 rock-solid pillars. These are the 2 checks you need to run on every single sentence. And the beauty of these rules is their simplicity. First up, relevance. Literally, have the pleadings open on your desk as you write. For every sentence, ask yourself, does this help prove or disprove an actual issue in this case? If the answer is no, get rid of it. And second, admissibility. This is all about first-hand knowledge. Is the witness testifying to this because they saw it, they heard it, they felt it themselves? These 2 rules alone will catch the vast majority of mistakes.
Okay, let's move on to the big one. The rule that trips up just about everyone, from junior lawyers to seasoned pros. The rule against hearsay. Nailing this is a massive step up in your journey as a barrister.
So here's the textbook definition. But let's get something straight. A lot of people think hearsay is just repeating what somebody else said, and that's part of it for sure. But the rule also covers your own witness repeating something they themselves said or wrote in the past if you're trying to use it to prove that what they said back then was true.
To make this easy, just use this 3-step test every single time. 1. Was this statement made somewhere other than this current court proceeding? 2. What facts are actually being stated? And 3, this is the key, are you trying to use this statement to prove that those facts are actually true? If you answer yes to all 3, then boom, you've got inadmissible hearsay.
And here is a perfect real-world example. On the left, you see Sylvia testifying to something she did directly. I posted the letter. That's admissible, no problem. But look at the right. Now she's trying to get her letter to her own solicitors into evidence to prove that she sent the original letter. That's classic hearsay. You just can't use a past statement to bootstrap the truth of what you're saying now.
Okay, so once you have the rule down cold, the next level of the game is mastering the exceptions, because knowing when a rule doesn't apply is just as crucial as knowing the rule itself.
Here's a classic you'll see all the time in cross-examination. Normally, you can't bring in your witness's past statements just to show they've always told the same story. But if the other side accuses your witness of making their story up just for the trial, what we call recent invention, then the door swings wide open. You can then introduce an earlier statement that's consistent with their testimony, not to prove the story is true, but to prove they didn't just invent it and to repair their credibility. It's a really powerful tool. This slide right here, think of it as your cheat sheet for the big 3 exceptions. First, admissions against interest. If the other party said something that hurts their case or helps yours, it's almost always coming in. And for documents, you've got to know your Evidence Act. In Queensland, Section 92 is your friend for documents made by someone with personal knowledge, and Section 95 is key for anything produced by a computer. Knowing these sections is absolutely essential.
All right, we've wrestled with the big, heavy theory. Now let's wrap up with some rapid-fire, practical rules that will take your drafting from just being okay to being genuinely persuasive.
Let's kick it off with rule number 3.
You have to be precise. Avoid summaries like, "we reached an agreement." That's a conclusion. Instead, state what was actually said. Using direct quotes, the actual words, is way more powerful. It basically puts the judge right there in the room with them.
Next up, rule number 5. This is all about clarity.
I know it sounds so simple, but it is so effective. Judges are reading huge stacks of these things every day. Make their job easier for them. Each paragraph should tackle one single idea. Short, sharp, focused paragraphs create a logical flow that's much easier to follow and way more persuasive than a giant wall of text.
And Rule 8, well, this is fundamental storytelling.
Unless you have a very specific, strategic reason not to, always tell the story in the order it happened. Our brains are just wired for chronological narratives. A clear timeline helps the judge build a mental picture of the events. Don't make them do the work of piecing it all together.
And finally, we're at Rule 15. And honestly, this might be the most important one of all.
This last one is all about authenticity. The affidavit has to sound like the person signing it. If your witness is a mechanic, their affidavit shouldn't be full of legal phrases like heretofore and aforesaid. It completely loses its credibility if a witness gets on the stand and doesn't even know what a word in their own affidavit means.
I really want to leave you with this quote from Kylie Downs, whose work inspired this breakdown. It just perfectly captures the right mindset. Drafting an affidavit is not a chore you have to get through. It's an act of advocacy. It's your first and sometimes your best chance to tell a compelling story that will shape how the judge sees the entire case.
So, as you go into your next case or as you're studying for the bar, don't just ask yourself, does this affidavit follow the rules? Ask yourself this, is it ready to persuade? Thanks for tuning in.